In this episode, we talk about the Supreme Court putting a stay on the government's fact-checking unit. We also talk about ASI delisting 18 centrally protected monuments. But first, we talk about Germany and the United States making statements about Arvind Kejriwal's arrest. Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. Delhi Chief Minister Arvind Kejriwal, who in an unprecedented move was arrested last week by the Enforcement Directorate in the Delhi excise policy case, has not been able to find any relief from courts. In fact, yesterday, a district court in Delhi extended his custody under the agency till the 1st of April. Now, the developments in this case are not only being followed by those in India, but even our close allies and strategic partners are keeping a close watch on it. In fact, both Germany and the United States have now made statements regarding the matter. The first one came from the spokesperson for Germany's Foreign Office, who during a press conference said that Germany assumes and expects that the standards relating to independence of judiciary and basic democratic principles will also be applied in this case, adding that, like anyone else, even Kejriwal is entitled to a fair and impartial trial. When we spoke to Indian Express's diplomatic affairs editor Shubhajit, he told us more about it.
In Berlin, they have a regular press conference at the German Foreign Ministry. So in the press conference on Friday, one of the spokespersons for German Foreign Ministry, Foreign Office, was asked the question about the arrest of Kejriwal. It is in that context that the German Foreign Office spokesperson made his statements on Kejriwal.
Now, after the German spokesperson made his comment, Shubhajit says that New Delhi got very upset, and the Ministry of External Affairs summoned the German Deputy Chief of Mission in the capital.
And on Saturday, and lodged a strong protest against the German Foreign Ministry's remarks on the arrest of Arvind Kejriwal. And there was a statement by the Ministry of External Affairs, which essentially said that, this guy was the German Deputy Chief of Mission, Georg Ensweiler. He was summoned today and was conveyed India's strong protest on their Foreign Office spokesperson's comments on India's internal affairs.
Shubhajit points out that the MEA spokesperson also said that they saw such remarks as interfering with the Indian judicial process and undermining the independence of Indian judiciary.
And said that biased assumptions made on this account are most unwarranted. So these were very strong statements made by the German Foreign Ministry, which upset the Indian government.
Now, he also points out that this is actually the third time that Germany has commented on developments taking place in India. The last time it did so was exactly a year ago, when Congress leader Rahul Gandhi was disqualified from his position as Member of Parliament.
So, in that case, the German Foreign Ministry had again made a comment that was again in response to a question at the German Foreign Ministry. And before that, it was about in July 2022, when the arrest of this fact-checker and alt news founder Mohammed Zubair, when he was arrested. So these were the past two instances when German Foreign Ministry had responded, but they had always responded in response to questions at the German Foreign Ministry's press conference.
Now, the comments by Germany were made on Friday, but a day after that, in response to an email query, the United States said that they encourage a fair, transparent and timely legal process for Chief Minister Arvind Kejriwal. And India's response to this was similar to the one it gave to Germany.
They again called one of the senior US diplomats based in New Delhi, whose name is Gloria Barbena, and she heads the public affairs section at the US Embassy in New Delhi. And again expressed its strong objections to the State Department's remarks. And it essentially conveyed that India has in diplomacy, states are expected to be respectful of the sovereignty and internal affairs of others, and this responsibility is even more so in case of fellow democracies. It could otherwise end up setting unhealthy precedents. The Ministry of External Affairs official spokesperson also said that India's legal processes are based on an independent judiciary which is committed to objective and timely outcomes. Casting aspersions on that is unwarranted. So again, it sort of came out very strongly against comments by the US State Department on what it felt were India's internal affairs. So the language was a bit different, but I think the tone, tenor was similar.
But a few hours after India summoned the senior US diplomat, the United States reiterated what it had said earlier. This time, it was the US State Department spokesperson Matthew Miller responding to a question.
What is your response to India's summoning of the US diplomat over comments regarding the arrest of Delhi's Chief Minister Kejriwal? And how do you view the recent political turmoil in India, including the freezing of the opposition party's bank account, as the Amnesty International described the situation? Crackdown on opposition reaches a crisis point ahead of national elections.
So with respect to the second question, we continue to follow these actions closely, including the arrest of Delhi Chief Minister Kejriwal. We are also aware of the Congress Party's allegations that tax authorities have frozen some of their bank accounts in a manner that will make it challenging to effectively campaign in the upcoming elections. And we encourage fair, transparent, and timely legal processes for each of these issues. With respect to your first question, I'm not going to talk about any private diplomatic conversations, but of course, what we have said publicly is what I just said from here, that we encourage fair, transparent, timely legal processes. We don't think anyone should object to that, and we'll make the same thing clear privately.
And Shubhajit, considering that both US and Germany are close allies and strategic partners of India, does it raise concerns that they are commenting on this issue? And do their statements end up putting any kind of pressure on India?
Well, firstly, the German Foreign Ministry spokesperson, when asked on Wednesday, a few days after the German diplomat was summoned, they sought to dial down the temperature and said that India and Germany have a great interest in closer cooperation and work together in an atmosphere of trust. So essentially, they tried to lower the temperature, whereas in the US case, they reiterated their statement, their points, as was said before. So there were a bit of difference in reaction after the summoning of their country's diplomats. Well, you're right. India has very strong strategic ties with both the US and Germany. They're both very close strategic partners. So, but in sort of India's case, especially in the last few years, whenever foreign governments have talked about India's internal affairs, India has responded very sharply. And that is visible, and especially in the middle of an election season, when India's sort of place in the world is one of the talking points, which is sort of claimed by and portrayed by the ruling party and ruling government. At this point of time, such comments have been sort of countered now. So that sort of tells you the politics behind this diplomatic pushback that has been done in the last couple of days.
And next we talk about the latest update regarding the government's fact-checking unit. Back in 2021, the government had introduced certain rules under the Information Technology Act to tackle the problem of fake and misleading news.
The idea of tackling misinformation that is online was one of the priorities of the government.
That's Indian Express's Apurva Vishwanath, who reports on law for the paper.
This is around the time when you had seen a spate of mob lynchings and things like that because of the dissemination of fake news online. So the government framed these rules ostensibly to tackle fake news. But what happened subsequently was in 2023, the government amended these rules. The government amended these rules and inserted one key provision, which is basically all fake news is on one side, but misleading or fake news on the business of the government, right? Which could be any information involving the government. For that, the government would set up a fact-check unit that would be under the Press Information Bureau of the government itself. And that fact-check unit will say whether something is fake or not about government business.
So by doing this, the government created a distinction between fake news of all other kinds and fake news that involves the government itself.
But the problem here is, Shashank, that it is the government which tells you what is apparently fake or misleading news. And there is a mandate in law that makes it obligatory for intermediaries to take down such news or content that has been flagged by the government. Say, for example, Facebook, Twitter, or even internet service providers like Airtel or Vodafone. So when the government says that this particular information we find to be fake and misleading about themselves, right? About their own business, the government business. So intermediaries are just obligated to take them down. There is no other way out.
And this raised concerns that the government, through these changes, wanted to be in charge of deciding what is true or not about it, and hence could stifle or censor any criticism against it.
Of course, there is again another layer of distinction here, that it is not about the content that is appearing in print, but only for online content. So only for online content, the government gets to take down whatever it thinks is fake and misleading. So that raises a lot of questions about how arbitrarily this power can be used. Say, for example, we are in the election season. Would a rhetoric speech by an opposition leader attacking the government be considered misleading news about government business? But does an opposition leader have the right to do so? So these are all questions that it raises. But when you know that the government could take down some content of yours, right? So any citizen would fear that. So there is going to be some chilling effect which will trickle down individually. Say, for example, I post something on Twitter. The government may not hold me up directly, but is going to tell Twitter to take down what I have said. The entire link will be gone. So this sort of wide powers that the government has to regulate speech online, this was essentially what was challenged in court.
Now, earlier this month, the IT Ministry notified the fact-checking unit that would be in charge and have the powers to flag what it believes is false information related to the central government and its agencies on social media sites. But just a day after that, the Supreme Court stayed the operation of this notification. In this segment, we speak to Apurva about the grounds on which these changes were first challenged in the Bombay High Court and what led the Supreme Court to stay its operation. Apurva, the concerns we talked about, were those the same ones that the petitioners flagged in this case?
Yeah, so it's essentially this twofold argument, right? One, that it creates a chilling effect and violates a citizen's right to free speech and expression. And two, the arbitrariness of the rules, the way in which the government can use it or, for that matter, misuse it on an issue that is so concerning, that is like fake news and misinformation, right? So these are the issues that were challenged before the Bombay High Court. Why the petitioners argued arbitrariness is because the amended rules essentially place the government as the sole arbiter of truth when it comes to anything about the government. So the perception of the government on what is misleading is the final word on the issue.
Right. So in this regard, the government is essentially saying that, I will be the arbiter of truth when it comes to anything to do with me. Talk about where this argument essentially falls flat.
See, the understanding is that right now, when there is, say, fake news online, there is nobody to sort of distinguish this as misleading or not misleading. But that's not true. There is a neutral arbiter of truth, and that is essentially what the job of courts is, right? What are judges for, if not for deciding whether something is true or not, something is factual or not? So it is the job of the judiciary to, as a neutral arbiter, decide whether something is fake or misleading. The problem we have with misinformation is not that we can't decide whether something is true or not, but it is the volume of information with which we cannot keep up. That is essentially the problem of misinformation, not really because we don't understand what is misleading or not.
Right, and we understand that after hearing this matter, the Bombay High Court had delivered a split verdict. Could you talk about how the two judges there saw this issue?
Yeah, so when the verdict came in January, a division bench of Justices G.S. Patel and Neela Gokhale delivered a split verdict, while Justice Patel struck down the amended rules and called these essentially censorship. Justice Gokhale upheld them. And what Justice Gokhale does is basically say that citizens have a right to participate in a representative government. And this right to participate in the democracy is meaningless if there is fake news circulating all around, if there is misinformation. So she places the right to access true information as part of free speech over the government's power to curb a citizen's fundamental right to free speech. So essentially what Justice Gokhale says is that a citizen's right to access information which is true and not misleading is more important than another citizen's right for her speech to not be regulated by the government.
Okay, so the Bombay High Court delivers a split verdict. There is no consensus. What happens after that?
So because it's a split verdict, the Bombay High Court rules dictate that a third judge would hear the case afresh. So then you would have a 2:1 majority depending on which way the third judge decides. So either the judge could go with Justice Patel or Justice Gokhale. So in February, Justice Atul Chandorkar was appointed as a third judge in this case. And from April 20th onwards, the final arguments are supposed to be heard by Justice Chandorkar, challenging the rules again. But in the meantime, the petitioners had sought for an interim stay, right? Because these rules are not even legislation made by the parliament directly, right? The Information Technology Act empowers the government to make certain rules about blocking content online, and exercising those powers, the ministry has formulated certain rules. So this is what we call delegated legislation. So the parliament delegates some powers to the government to frame these rules, and the ministry has done those. These rules, essentially what we call delegated legislation, have a much higher threshold before the courts on basically how vague they can be.
And could you elaborate on what that means when we say that these delegated legislations have a much higher threshold before the courts?
So when Parliament makes a law, there is a presumption of constitutionality, which means till a court strikes it down, the presumption is that the Parliament has made a law which is, of course, in sync with the Constitution. Only on an explicit finding of unconstitutionality that the court strikes it down. Basically, the courts will not stay a legislation, not stop the operation of a legislation made by Parliament, because it represents the will of people, right? Not before it strikes it down. But here in this case, that level of presumption does not apply to rules made by a ministry. Those have a different standard that the court can look at. So in that case, it's not very unusual to find that the rules were stayed before a final verdict has been reached by the court. So the petitioners wanted an interim stay on the rules, but the Bombay High Court at that point, that is Justice Chandorkar, declined. So the petitioners then filed an appeal before the Supreme Court. So which is what we saw last week, but the Supreme Court granted the stay.
Right, and Apurva, what happens now? Where does the case go from here?
So for now, the case goes back to the Bombay High Court. The third judge, that is Justice Chandorkar, has to hear the case, which will be from 20th of April. After the final arguments in that case or the final decision, then the constitutionality of the rules will be in play. Depending on which way Justice Chandorkar rules, it can land in a further appeal before the Supreme Court.
And in the end, we talk about centrally protected monuments. The Archaeological Survey of India, which is responsible for archaeological research and the conservation and preservation of historical monuments in the country, has now decided to delist 18 centrally protected monuments. And this is because they have decided that these monuments do not have national importance. But it's key to note that these 18 monuments were part of an earlier list of monuments that ASI said were untraceable. To know what delisting means for these monuments and how they became untraceable, we speak to Indian Express's Divya A in this segment. Divya, when the ASI says that it's delisting these monuments, tell us what exactly does that mean?
So essentially, we have to understand that the act which governs all the monuments, all the heritage in India is the Ancient Monuments Preservation Act, or the Ancient Monuments and Archaeological Site Remains Act of 1958. There was a time that when this act was formed, it had no provision to delist a monument if it has become untraceable. So now they are invoking a provision which says that you can delist a monument if it ceases to be of national importance, which is this section 35 that has been invoked in this case. So when you delist a monument, it's not centrally protected anymore. So the onus is not on the Archaeological Survey of India, which functions under the said act that I just mentioned. There is no onus on them to maintain the monument, to preserve, to conserve. And also there is no regulation which bars construction around the monument.
Right, and like you said, these monuments that are now being delisted are the ones that ASI says have become untraceable. Could you explain exactly how that came to be?
So over the years, ASI has taken many monuments under its fold, under its protection. And now the list runs into 3693. It's about 3,700 monuments, which includes all kinds of these things that I mentioned, which come under ASI protection. But there has been no effort on the part of ASI. I mean, you take a monument under your wing, but there has been no consistent effort on the part of ASI to do like a physical check of all the monuments. So that physical verification exercise has never been done, especially in case of these smaller monuments that are now lost, or untraceable.
So basically the ASI can take a monument under its wing, but it could just be on paper. There is a chance that it won't physically visit the site.
So when you take a monument under your wing, you have to physically check, and then there is also the onus on you to make sure that it is existing, under its present form. But unfortunately, that didn't happen. To a parliamentary committee in late 2022, where ASI was really given a dressing down for these untraceable monuments, ASI quoted several reasons like shortage of security personnel, shortage of conservationists, shortage of funds, and all of these things. So overarching exercise has never been done. You take a monument under your fold, you post some people, you put it under some circle, because ASI works in divisions. So ASI has some 20 circles which are divided region wise. So the regional circle is supposed to take care. And unfortunately, that didn't happen. So some of these things are lost.
Yeah, and you write that these monuments have been lost to urbanization, encroachments, the construction of dams, or even sheer neglect. And ASI was the one that was supposed to keep a track of them, but it did not. So do we know how many such monuments have been lost this way?
So the CAG had flagged that about 92 of these monuments were missing, but then ASI made some efforts, and some 42 of these 92 monuments that were flagged were later found. Found means they were either shifted. If it's a small thing, maybe the place was shifted a bit. Maybe it was in some other, under the mud or something, which they rediscovered. So through some random efforts, some 42 monuments were rediscovered or found. But however, 50 remained missing. So out of these 50, they have said on record that 26 have been lost forever to either urbanization or submerging under reservoirs or dams. Otherwise, so we are left with 24 of these monuments that are untraceable. They don't know what has happened to them. There is no idea. So this list of 18 has been drawn from that list of 24 untraceable monuments for which they have no answer. So it was almost a year ago that these untraceable list came into circulation. And ever since, there have been efforts to figure what to do with this, because there is no provision to, like I said, delist untraceable monuments in the Act. So essentially, you have to invoke a provision which says that they have ceased to be of national importance.
You were listening to Three Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.